Well, ladies and gentlemen, and those watching online, welcome back. We're delighted to have for this third session representatives of the Australian Human Rights Commissioner, including the Human Rights Commissioner himself, Mr. Edward Santo, and Mr. John Howell, the Director of Human Rights and Scrutiny. Under my Act, one of the matters I'm explicitly required to consider is the extent to which laws contain appropriate safeguards for protecting the rights of individuals, and under Section 10 of the Act, one of the persons I am expressly invited to consult with is the Human Rights Commissioner. So I'm grateful for you both being here. Did either of you have an opening statement?
Thank you for the opportunity to speak with you and to provide this opening statement. The Australian Human Rights Commission recognises that states must be able to combat terrorism effectively. That means, for example, ensuring that law enforcement agencies can themselves effectively prosecute terrorism offences and that courts can impose appropriate penalties to protect the community from risk, including the risk of terrorism. We also recognise that a child is a special category of accused or offender. The human rights issues that arise in the prosecution and sentencing of a child should be considered by close reference to the UN Convention on the Rights of the Child, CRC. In particular, the child's best interests always must be a primary consideration. It's no surprise, therefore, that a counter-terrorism measure might be compatible with Australia's human rights law obligations when it applies to an adult, but not in respect of a child. Under international law, federal, state and territory rules on bail, prosecution and sentencing of children must comply with the Convention. In a federal system such as Australia's, that does not require that those laws all be identical, but rather only that they each comply with the Convention. We've recommended a comprehensive survey of state and territory laws be undertaken to identify where laws don't comply with the CRC. It might be that a coordinated approach involving the Commonwealth states and territories is ultimately required to ensure full compatibility with the Convention. Turning to the mandatory minimum non-parole period in Section 19AG and the presumption against bail in Section 15AA, we note that such provisions do not generally apply to children and young people. The Commission urges a more orthodox approach in this specific context, namely that the ordinary rules regarding non-parole periods and bail should apply to children and young people charged with these offences. The CRC requires that deprivation of liberty, including arrest, detention and imprisonment, be used only as a, quote, measure of last resort, unquote, and for the, quote, shortest appropriate period of time, end quote, so as fully to respect and ensure the child's development. The UN Committee on the Rights of the Child has said that protecting the best interests of the child means that traditional objectives of criminal justice, such as retribution, must, quote, give way to rehabilitation and restorative justice objectives in dealing with child offenders, end quote. Any measure depriving the liberty of a child must be scrutinised against that standard. A mandatory minimum non-parole period makes it impossible for a court to consider even unusual and highly compelling evidence that militates in favour of a lower sentence. This is doubly significant in respect of children and young people because depriving a child of their liberty has additional negative impacts that are peculiar to children. It negatively impacts the child's development, their education and capacity to integrate back into society. Section 19AG sets the relevant non-parole period at 75% of the length of the head sentence. It exacerbates the impact because, especially in the case of Commonwealth terrorism offences, head sentences can be very high. The rigidness of a minimum non-parole period makes it very difficult to determine how the child's best interests could be a primary consideration. So we consider that by virtue of their age, children always fall within the scope of exceptional circumstances for the purposes of Section 15AA. There should be no presumption against bail for them. To the contrary, the principles regarding deprivation of liberty of children support a presumption in favour of granting bail. The presumption is displaceable, of course, where a court is satisfied that bail would not be appropriate in all the circumstances, including where the best interests of the child are outweighed by other factors. That determination can be made under relevant state and territory bail laws in the ordinary course. We would be pleased to answer any questions.
I just had a question of terminology before handing over to Mr. Tran. The consistent language in the international, in the convention and in subsequent declarations is the best interest of the child being a primary consideration. When the Australian Law Reform Commission looked at this, they adopted what they said was a synonym, namely the best interests of a child be a guiding consideration. And the reason they articulated for that is they said a primary consideration might give the impression that it's to be the overwhelmingly important consideration rather than a primary consideration. But I see, for example, in the Beijing rules, it's moved from a consideration, I think, to the consideration. How should I understand the correct form of words needed in an Australian statute to comply with the convention?
Yeah, I mean, I think there is clearly some confusion, perhaps, and sometimes some debate over this, but the position at international law, I think, is relatively clear. The words used in the convention are probably the best words to use, a primary consideration. What that means is that there may be other considerations that also appropriately have the same status. Yes. In other words, there may be more than one primary consideration. Yes. There can never be a consideration that overrides that is greater, that is more important or more compelling than a primary consideration, if that makes sense.
I see. So you might have seen in my opening remarks, Mr. Santo, that I referred to, I think, the approach taken in control orders with children, where I think at the suggestion of the PJCIS, the best interests of the child were a primary consideration, the protection of the community or similar language was the overwhelming, what's the word?
I think the word you used may have been paramount.
The paramount consideration. So do I take it from what you've just said that is non-compliant, a non-compliant approach?
I think the better view is to refer to the interests of the child being a primary consideration, identifying whether there are any other primary considerations. I think as a matter of practice, there may be other primary considerations in a particular situation that run contrary to the best interests of the child, and that may, in a particular instance, have to be kind of outweigh, that may outweigh the best interests of the child. And so, as a matter of practice, it may take you to a very similar point. But as a question of law, I think it is the better view to refer to an analysis of what, if any, other primary considerations there are.
Thank you, Mr. Santo.
Now, Dr. Rennick, in his question to you, Mr. Santo, referred to the Beijing rules. I was wondering, would you be able to explain, for our benefit, what the status of the Beijing rules is?
Just confirm one thing. Basically, I mean, they're a statement or a set of principles that are adopted by the General Assembly, so they have the status of any other resolution of the UN General Assembly. What is particularly important to remember in respect of the Beijing rules is that they seek to apply in this specific detention context a range of international human rights law principles that find voice in treaties to which Australia is a party, such as the International Covenant on Civil and Political Rights and, of course, the Convention on the Rights of the Child.
So in approaching our assessment of the compliance of these laws with Australia's international obligations, the approach that we should take is to look at what the Convention says as perhaps illuminated by these various statements and rules adopted by the UN General Assembly. Is that the way that we should go about it?
Yes.
Now, thank you for setting out the Commission's views about sections 19AG and sections 15AA in your opening remarks and in writing. It might be useful if I ask you to respond to the view that's been presented by the Commonwealth about the compliance of these provisions with the Convention, for you to offer your response. In relation to section 15AA, the view was put that section 15AA complies with the Convention on the Rights of the Child because the decision whether to grant bail is always ultimately discretionary, and part of the discretion has regard to the fact that it is a child that's before the bail authority. In your view, is that enough to make section 15AA compliant with the Convention?
No. Refer you to the comment by the United Nations Human Rights Committee, which is the body with responsibility for overseeing compliance with the International Covenant on Civil and Political Rights. In 2008, it expressed particular concern in respect of section 15AA, precisely because it appears to reverse the burden of proof, contrary to the right to be presumed innocent. So, in other words, while a provision like 15AA preserves some elements of discretion on the part of the court and may also admit of situations, of course, where people are granted bail. The concern here is that it tilts the playing field in a way that makes it more difficult to obtain bail than international human rights law requires.
Does your answer mean that any stipulation or any restriction on bail that requires exceptional circumstances to be shown would be inconsistent with Australia's international obligations?
I need to consider fully all of the implications of that. I'm really making a narrower point, and that is that this specific restriction on when bail may be granted in respect of children is not compatible with international human rights law.
And would your answer be different if it had a restriction that said you still have to show exceptional circumstances, but in making your overall determination about whether to grant bail, the bail authority is to treat the best interests of the child as a primary consideration?
I think that would improve the provision. Whether it brings it within compatibility with the relevant international human rights law is still perhaps in doubt. I think our submission proposes that either you treat simply by the fact of being a child as satisfaction of the exceptional circumstances requirement. That would be one way of achieving it, or if you simply didn't apply the exceptional circumstances requirement in respect of children and instead enable that to be a primary consideration, the best interest of the child be a primary consideration, that may solve it. I'm not immediately convinced that would be that the proposal you just made would fully satisfy international human rights law.
Can I understand?
Mr. Santo, sorry to interrupt. Does it suggest there's a 37B problem with that concept? In other words, if it's still exceptional, but you have to take into account the rights as a primary consideration, does that undercut the idea that detention, including with bail, is a measure of last resort? Is that part of it, or...?
I defer to my colleague John Howe.
Yeah.
If I might at least give a preliminary answer. Yeah, that's the case. Article 37B of the Convention on the Rights of the Child does stipulate that detention must be a measure of last resort, and that applies at in all circumstances where a child might be detained, including after arrest, when bail is being considered, during sentence, and at any time after that. So it would seem, to my mind at least, that Section 15AA as currently drafted really makes detention a question of first resort rather than last resort, because the presumption is detention unless a particular hurdle or standard is met, whereas the approach that would be more consistent with the Convention would be that there be a presumption that a child not be detained and therefore be granted bail. Obviously, that could be overridden in particular circumstances if there were other primary considerations that made that the sort of the preferable or the only sort of consistent outcome.
Is there any room in considering Section 15AA for a different approach depending upon the age of the child? So someone who's maybe 17 compared to someone who's 12? Or is it the case that the Convention would require Australia to treat them both in a similar fashion? And by similar, I mean making sure that you don't start with the presumption that they are to be refused bail, and you make sure that they're entitled to primary consideration of their best interests.
Well, considering the best interests of the child actually has some adaptability included within it. And so the best interests of a very young child may look different from a child of 17 years. So it would certainly not be necessary to, in the legislation, make that distinction that you're referring to, and in fact there may be a series of unintended consequences of doing so.
And so I think from your answer, Mr. Santo, we may draw from that the proposition that the Convention stipulates some standards that have to be followed, and those are indelible: best interest of the child, last resort. But how that actually plays out for each individual child, you need to give the decision maker a degree of discretion in order to reach the right result consistent with those standards in that case.
That's correct. And precisely what the Convention is intending to do is to enable individualised decision making that takes into account not the best interests of a hypothetical child, but the best interests of the child before the decision maker.
I might move on to Section 19AG, which, as you're aware, sets out the three-quarter rule that prohibits a sentencing court from doing anything other than imposing three-quarters non-parole period of the head sentence. As I understood it, the Commonwealth position was that Section 19AG complies with the Convention on the Rights of the Child for a few reasons. First, because children who are convicted of terrorism offences need a degree of time in prison in order to undergo the de-radicalisation or disengagement process. Two, the sentencing judge will still have a degree of discretion, not as to the non-parole period, but relevantly as to what sentencing disposition to impose upon that particular offender. Do you have a response to those positions?
Taking those propositions one by one, just for the sake of argument, we would accept proposition one, namely that there's a certain minimum amount of time that offenders who are children, terrorist offenders who are children, need to be de-radicalised. That assessment is best made by the court that is considering all of that individual's circumstances. It is very difficult for Parliament, without reference to any individual child or young person, to identify what is the specific minimum time that will apply to all child offenders in that category. In other words, if we accept that objective as a legitimate one, it can still be achieved by preserving or granting a greater degree of discretion to the court in determining length of sentence than current Section 19AG. In respect of the second proposition, which is essentially that there is some residual discretion, that may be true, but that does not, I think, fully answer the charge that this provision is incompatible with international human rights law. The point is the two critical provisions of the Convention on the Rights of the Child that are enlivened here, Articles 37 and Article 40. We've talked already about detention being for children a matter of last resort. There are other really important principles, such as that detention should be for the shortest appropriate period of time. I think what the current drafting of Section 19AG militates against is compliance with that specific requirement. And so we would particularly draw your attention to that.
From the Commission's perspective, I'm sure you're aware that federal offenders have their parole determined by the Commonwealth Attorney General, which wasn't always necessarily the case. Can you see any necessary reason why Section 19AG would need to remain for children in circumstances where the ultimate decision about parole and risk presented by an offender is vested in the Attorney General?
And perhaps, sorry, the extra point perhaps to the question is there's no presumption of parole anymore. You used to get parole automatically, now you don't. Indeed, the attorney was reported recently as having personally declined to grant parole to a young offender.
Yeah,
who will now serve their full.
Yeah, thank you for drawing that to our attention. Perhaps we should take that question on notice and consult with our colleague, the National Children's Commissioner, as well, because she might well have a view on it.
Sure. Now, I think another point that's raised in the written submissions in support of Section 19AG's consistency with Australia's international obligations is the proposition that Parliament has made the determination that certain offences warrant the three-quarter rule, and that there's not necessarily any international obligation that would require that determination to be made by a court looking at a specific offender, a juvenile offender. Do you have a response about where decision-making authority needs to lie from an international perspective?
I mean, the problem is not who has made that edict. It is that requirement carries with it a level of arbitrariness that makes individualised decision-making either more difficult or, in one sense, impossible. And it is that requirement of individualised decision-making that at international human rights law is crucially important here.
I'm going to ask some questions about 20C. Do you have anything else? Just a couple of other more general questions, Mr. Santo. So in Australia now, I think Queensland this year changed the definition of children so that now it's uniform across Australia that it's 18 and up. But there are still differences in Australia as to which sort of detention facility you are capable of being sentenced to. As we know, there are no federal prisons. So in New South Wales, for example, the sentencing judge may, him or herself, order that you serve generally up till 21, although sometimes up to 23, in a juvenile detention facility. That doesn't preclude the prison authorities transferring you for cause to an adult facility, but that's certainly where you start. Whereas in other states, 18 and one day, you're in an adult facility. Do we have anything to learn from human rights law about that differential treatment of young adults as opposed to children?
This is perhaps another example where international human rights law requires individualised decision-making wherever possible. In this situation you're talking about here, we would say that the individuals we're talking about here are both the individual offender who's perhaps just gone over that age threshold to be 18, so what are that person's best interests, but also what are the best interests of the children in the children and young people in the juvenile facility, and if the 18-year-old's continued presence might impinge disproportionately on their basic human rights. And so I guess what we're saying is consideration needs to be given to both of those categories of person on an individualised basis. A blanket rule makes that either difficult or impossible.
Right. Something else you may have, you haven't really had a chance to read in detail my opening remarks, but one of the things I have found striking in this inquiry is how you could have very different sentencing results depending upon which state or territory you happen to be tried in, and whether you are tried in a children's court or a general court of general jurisdiction, and whether you were tried by reference to juvenile justice principles or as an adult, for example, as a co-offender with an adult. And you may have read that my starting point is that while some discrepancy for a federal offender might be acceptable in a federal system, very marked discrepancies are unsatisfactory. And so my starting point is essentially for serious terrorism offences where a substantial period of incarceration is going to be awarded. It seems to me that in principle they should be determined by a judge and jury of a Supreme District or County Court. It is not appropriate for those to be dealt with by a children's court, not least because it will exceed their normal jurisdiction to impose the sentence required by law. There will obviously be some matters at the very bottom end of severity where children's courts, with their particular expertise in that jurisdiction of dealing with non-custodial options, may be very well suited, and no doubt there's a grey area in between. Now, from my legal policy point of view, there's no hard and fast answer as to where you set those relevant limits. New South Wales and Victoria, for example, have made both legal and procedural changes which mean that, for example, people facing a sentence of life imprisonment or 25 years cannot be dealt with in the children's court, but in other states you could be. And in Queensland you can be dealt with by a jury. I suppose I'm asking, and you may wish to take this on notice, does human rights law, that large body of law, have things to tell me about when a matter should be dealt with in a children's court, when a matter should be dealt with in a court with a jury, where after all it's one of our very few constitutional rights? And pausing there, the English Defence Counsel I spoke to were all adamant that if they had the choice they would want a jury trial. So you can see there's some complex issues here, and if there's any guidance you can offer as to, by reference to what human rights principle one should set that standard or limit or whatever you might characterise it as, I'd be grateful. I appreciate that's not an easy question.
No, I can make two quick observations, and perhaps we can reflect on it further and see if we have anything to add.
Certainly.
The first, to return to something I said right at the start, consistency is important in this area. That's not the same thing as saying that all of the laws in a federation like Australia have to be identical.
Yes.
But a divergence, any significant divergence prima facie should raise a red flag, particularly when that divergence has an impact on the experience of the individual's basic human rights. Any deprivation of liberty does. Second proposition is that in addressing that consistency issue, international human rights law would encourage us to be very careful not to level down, as it were. In other words, uniformity should never be achieved at the cost of reducing human rights protections for children in any particular state or territory, or for that matter, nationally. So those principles, I think, are very important. Returning to our submission, we were quite careful about how we approached this issue. We said that the first step really needs to be a very careful survey of Australia's federal, state and territory laws to identify very precisely where some of those divergences are that you are talking about. When I say some of them, all of the divergences are that you're adverting to, so that you can then take a practical approach in determining how best to address those divergences. And that may be individual jurisdictions, state and territory jurisdictions, legislating to bring themselves up to speed, as it were. And there may be times where there's agreement for the federal parliament to legislate to address a problem. But I think that's the sequence that probably needs to be followed.
I might add something just on the question of when it might be appropriate for particular offences to be dealt with by a children's court as opposed to a court of general jurisdiction.
Certainly.
And this is a very general comment. There are a number of features of children's courts which are particularly adapted, make them particularly adapted to hearing matters involving children. Obviously, the range of sentencing options available is one that you've adverted to and is a very major factor and advantage of children's courts in many circumstances. There would be nothing to stop, and in some jurisdictions I believe this does happen, courts of superior jurisdiction having those same sentencing options available to them when they are hearing a matter that involves a child defendant. There are a number of other features I believe some children's and youth courts have, which again are tailored towards children's particular circumstances, including a judiciary which is particularly skilled at dealing with child participants to litigation and their particular needs in terms of making themselves heard and obtaining proper representation and having their interests well represented. And again, there is a possibility that courts of higher jurisdiction, it may require some legislative or other procedural amendments, could make the same adaptations or have the same training available to judicial officers and others involved in the registry and so on in the court to provide them with some of those features which make them better placed to protect the rights of children when they're determining serious offences involving children. So to the extent those adjustments can be made, international human rights law may be slightly agnostic about which particular court would be most appropriate to hear an offence, but the critical factor would be, is the court well placed to protect the rights of the child by ensuring that they can be heard, ensuring their other rights are protected and that an appropriate range of sentencing and diversionary options are available to whichever court is ultimately hearing a matter.
That's a very helpful observation. I mean, certainly in England, the comment was made that some judges are very quick to adapt their practical procedures when children are on trial. For example, they might not wear wigs or robes. The child might not be in the dock. The child might have a support person next to them, even if charged with a very serious offence and so on. Now, I suspect those are matters best dealt with by judicial training rather than prescription by law. Because it won't be what's appropriate in one case won't be appropriate in another. So I take your point there. And I also take your point that it's a good thing generally for judges to be exposed to judicial education about children. I mean, one of the things I'm thinking of recommending is that in New South Wales, for example, all judges may visit a jail or place of detention on reasonable notice, and many of them do so, certainly in their initial judicial training, But there are some experienced criminal judges who make a point of going every year on the basis that, well, I'm sentencing people to go to this institution, I should know what it's like. And I think that's to be applauded. And indeed, I'd be interested in your views on this, but I'm considering recommending that that be a right of all judges to visit any place where a federal offender might be incarcerated. That would be a law supported by Section 120 of the Constitution. It wouldn't cost much, but I think it would encourage judges, if you couple that perhaps with some judicial training through the Judicial Conference of Australia, to be familiar with what's happening. And after all, civil judges sometimes sentence people to jail for contempt and the like. So if you had any thoughts in relation to that, I'd be grateful.
We would strongly endorse that proposal. That there are, as you acknowledge, some judges who, as a matter of course, do visit places of detention, and I think find that instructive in the carriage of their duties. I think that particular issues that arise for children in places of detention probably add additional weight to your proposal, so we warmly endorse it.
And one might add, I suppose, to that, that if an issue in cases, not just criminal cases, but high-risk terrorist offender matters, is the extent to which people are rehabilitated. I mean, there are some people who take the view that there's no such thing as even disengagement from violence, and yet the learning on that suggests otherwise, and it may be that having judges go to visit places and see what progress is being made in disengagement and rehabilitation would be just helpful generally in that sphere.
I think so. I think it gives a practical understanding of the sorts of measures that are often discussed in as different parties are reducing evidence. Of course, it's no substitute for looking at the cold hard data on what is effective and what's not effective. But I think it's a probative piece of evidence, as it were.
Chris, did you? Yeah.
Just returning to Section 20C, does international human rights law provide any insights into how to reconcile federalist concerns with the right to equality? So on the one hand, Section 20C, which allows us to pick up state and territory procedural laws for criminal offences, is there in order to preserve and reflect federalist concerns. But on the other hand, what we're seeing in our review so far is that potentially very divergent results might follow depending upon where the trial takes place. I was wondering, does international human rights law help us to draw the line at a particular point?
It definitely provides some assistance, perhaps not an absolute black and white rule that is of easy application in all circumstances. What the UN Human Rights Committee has said is that in a federal system, the right to a fair trial does not require uniformity in respect of all procedural rules across all of the jurisdictions that make up the relevant federation. However, where a significant procedural right is enjoyed by people to a different extent solely on the basis of the particular state or province or territory, in Australia's case, that they live in, that difference may impermissibly limit the human rights of the affected person. That could be, in breach, for example, of the right to a fair trial. It could also be in breach of the principle against discrimination. It will depend, and this is why I say it's not an absolute black and white rule that can be applied very simply in all circumstances. It will depend on the nature and extent of the difference in the application of that procedural rule. And so it really needs to be considered on a case-by-case basis. But certainly in the context of Section 20C, I think there are some examples, particularly given in the government joint submission, of where there are some very significant divergences as between the experience in different jurisdictions in Australia, and I think they need to be very closely assessed.
Sure. If there's nothing further, it remains for me to thank both of you for coming to Canberra, for making a very detailed submission. If you did have any further thoughts arising out of today, perhaps we might have them in 14 days if that's convenient. Not suggesting there do need to be any further ones. And again, I always value, Mr Santo, the work of the Human Rights Commission and you personally, so thank you very much.
Thank you very much, John.
So we now welcome our last witness for the day, Ms Jessie Smith, who I think is appearing on behalf of the ICJ in Victoria, is that right?
Yes, that's correct.
Yes. Do you have an opening statement, Ms Smith?
I do. Look, I'd like to start by echoing the acknowledgement of country made by Dr Browell earlier today. And I'd like to thank you, Dr Rennick, counsel and solicitor assisting the INSLM, for inviting me to attend and give this submission today. And I do so as a representative of civil society, both the International Commission of Jurists Victoria and my firm Starry Norton Helfen. The International Commission of Jurists in Victoria is committed to the primacy, coherence and implementation of international law and principles that advance human rights. I'm also appearing with the support of Liberty Victoria. Liberty Victoria is one of Australia's leading civil liberties organisations working to defend and extend human rights and freedoms in Victoria. In my professional capacity, I'm a solicitor with joint conduct of the largest terrorism law practice in Australia under the supervision of Mr Robert Starry, the principal. I was also solicitor for MHK, a 17-year-old who pleaded guilty to acts in preparation of a terrorism offence in 2016. His case is discussed at length in our submissions and also by the Law Council of Australia in their submissions and elsewhere. I also have a personal research interest in this field and will shortly commence a PhD examining the judicial assessment of terrorist risk. If I may, most of my submissions will focus on the Section 19 AG. Most of the submissions that were filed before the INSLM have called for the repeal of this section. And in our submissions, we flag at first the history of Section 19 AG, the importance of parole, and especially the importance of parole as a protective mechanism to protect the community against recidivism, and that's done by facilitating the reintegration and rehabilitation of offenders. Our submissions flag the introduction of the bill, which suggests that senators had a very short time frame in which to consider the inclusion of Section 19 AG to that raft of amendments, and that there was not great scrutiny at that time as to the human rights implications, especially towards the ICCPR and Convention of the Rights of the Child at that time. What Section 19 AG is designed to do is not at all protective. It does not determine if someone will be released on parole. It just sets a mandatory minimum marker. And I think that's an important distinction to make some of the earlier comments that this was somehow necessary due to the nature of the offending, that accused had to be held for a longer period. Really, this is dealing with the time that eligible offenders will be released. It does not direct the release of those who pose too much of a risk. So
I suppose as a matter of statutory construction, we need to draw a distinction between 19 AG at the time it was first enacted, when it would have done that,
yes,
and the position now. So you're talking about, understandably, about the position now.
Look, at the time as well, Section 19 AG was always, even though it was an automatic process, and perhaps I'd need to consider this further, if an offender caused a substantial concern or a risk concern, query whether application could have been made by the parole board or those concerns raised. Yes, since 2012, the Minister has exercised a personal discretion towards offenders, which changes the quality of this regime. But since its conception, it's been primarily focused on giving a, I suppose, blanket and mandated guideline for a particular kind of offender, regardless of risk that they might specifically pose to the community. And that, when considering the broader regime of parole, we see as particularly problematic. The submissions also briefly flag some of the human rights concerns of this particular brand of mandatory sentencing, which it considers to be, although lawful, potentially arbitrary according to the Convention of the Rights of the Child. And the gravamen of this, or the thrust of the submissions, really concern the structural barriers to the rehabilitation of child offenders, of which 19AG forms a central part. To that end, and to discuss that further, I've prepared a small aid for this discussion, which I've handed to Dr. Rennick and counsel assisting.
Yeah.
When a young person comes to the attention of authorities, there are various stages which they will move through in the criminal justice system. Pre-charge, we understand there are some diversionary programs. However, as solicitors who practice in this area, we're unaware of what they are. We've not been notified of what those programs are, and we've never made a referral to them. That is despite a constant stream of young people coming through our office with passports cancelled or because they've raised concerns with their parents. We have made several requests for that information at various conferences, but it's unclear what programs might be suitable for young people who are presenting with that behaviour profile. From that point, little remains to assist to rehabilitate or disengage de-radicalise offenders. You have the control order regime, which, although it mandates through the controls that rehabilitation is to take place, there is no funded programs or indeed guidance as to what that should look like, and it's left to practitioners to fashion pro bono in their own time. Once an accused is charged, there will be potentially a bail application. If they're released on bail, there are no programs like there exist for every other category of offender in Victoria: violent crime, sexual offences. There still remains nothing. If they're refused bail, they will be placed on remand, and that can span 18 months to 4 years. Because of the intensely complex nature of these legal regimes, we have had several cases run of that duration, and there are no programs. Now, if at any stage along that trajectory an offender is acquitted or the charge is discontinued, they will leave the justice system having received absolutely no supports for their presenting risk profile. Then we come to the sentence hearing, where the judge is required to apply Section 19AG in fashioning a sentence. At that stage, the judge at common law is required to, the offender really is required to renounce violence in satisfaction of the sentencing principle of community detention. This is a sentencing principle that commenced with Lodi's case and has been employed since, and has developed into an expectation that the accused will give evidence and be cross-examined. This has never occurred in Australia until the case of MHK because of the total absence of appropriate rehabilitation programs for this kind of offender. There is no evidentiary basis for which the court to draw on, and there's no mechanism to assist an accused to know, understand and position themselves to renounce violence, not just as an oral surrender in court, but as an actual meaningful step away from violent extremism. So
just pausing there, there's two ideas. There's the idea about whether the accused, no doubt on legal, or the offender, no doubt on legal advice, chooses to get into the witness box on sentencing.
yes.
That's idea number one. And then the second one is, if and when they do that, your point is, I think, that there isn't publications which will assist in the court determining whether that renunciation is genuine.
But both would require programs to create the conditions for either an oral renunciation or the court's assessment of that risk. Mm-hmm. In my view, an accused offender cannot renounce violence unless they've worked closely in what that means, because renunciation is to step away and to disengage or to de-radicalise from violent extremism. And unless the courts are going to entertain perfunctory, ideological renunciation that has no meaning and is not otherwise born of significant engagement with support services, then that can have no meaning, and it's no surprise that no offender has ever been in a position to do that until MHK. There were, attempts to admit a renunciation through a psychologist that happened in Bessim's case, and I believe that's happened in New South Wales as well, but that has not been accepted.
So when you say it hasn't been accepted, you mean the conclusions haven't been accepted, not that they haven't been admitted into evidence?
The court has not relied upon it or put... I'd have to go back and read the judgment to see whether it was capable of being admitted and then given little weight, or it was simply inadmissible.
I see. So what are you suggesting then at the pre-sentence stage?
What needs to occur, ideally pre-charge, but at least from the point of charge, is either in custody or in the community on bail, programs to assist offenders while they're in this forensic setting. Now, these were submissions that were made to the Harper Lay Review and are contained in their report on terrorism and violent extremism in Victoria, and that's recommendation 10 and 11 of their second report. But that needs to be accompanied with statutory protections of that therapeutic space. And one of the barriers that we have confronted as practitioners in counter-terrorism is that all of this engagement, all of the subject matter that you would be discussing with the young person, the psychologists, the imams, the social workers, all of that goes to ideology and all of that is admissible at trial. It all goes in under the advancing cause limb of a terrorist definition under the code. And there has been no desire to put clients' trial at risk by facilitating their disengagement along the way, and that is such a lost opportunity in our respectful submission.
But after they've been convicted, is the problem that there isn't enough time? Is that the concern? Or?
Well, after they've been convicted, the time between conviction and sentence is usually of short compass, and to do a meaningful disengagement from violence, as we've heard, it does take significant time. It's certainly not something that can be done in a perfunctory way. And there's not much interest from a defence practitioner's experience to sort of fashion together something so quickly if it's not going to be meaningful and meet what the common law requires.
I mean, I can see if there's a decision to plead guilty, the court perhaps being sympathetic, and Ms Single may know more than me, giving a reasonable adjournment to permit some proper examination. I suppose, though, if it's a plea of not guilty, there's the classic dilemma.
But at the same time, there is the classic dilemma, but at the same time, you're charged with potentially a pre-incohate early preparatory activity, often several years before. 4 years later, in that time, are they to sit in isolation or are they to work towards disengaging from violence? They can still contest the charge. It's not inconsistent with that, but it allows really for the justice system to secure what it needs to consider in terms of verdict and achieve a safer community as a result. Because if they walk, like we saw with Yaqub Khaire in the Operation Neath proceedings, he spent 4 years on remand in a maximum security prison and went on several years later to commit the Brighton siege attack, which killed one person. Yes, his case is complex and there is an extraordinary, confluence of factors in his case, but surely as an aspect of that is 4 years in maximum security prisons, 23-hour lockdown.
So just so I understand this, is this all relevant to your submission on 19AG?
It does, and I'll put this how it's relevant. 19AG has been another impediment for us making real inroads in the therapeutic space, because the court must impose a mandatory non-parole period. So what is the value in disengaging? Where is the motivation? Where is the encouragement or the facilitation of that process if we know exactly what sentence they're going to receive, and there is a marked similarity between sentences that adults have received over the years. It's often 20 with 15, thereabouts. And this is the dilemma that the Honourable Justice Lasry found himself in at the sentencing stage of MHK, where even though he recognised that there had been, well, in the history of counter-terrorism, quite extraordinary rehabilitation, evidently still distance to travel. But His Honour had to impose something that looked like ultimately, because terrorism offences are so serious, you're always going to have a high head sentence, and you will just have a mandatory parole period, which gives absolutely no consideration to those efforts. And
so apart from amending 19AG to say that it doesn't apply to children, are you making any other recommendation to reforming the law, bearing in mind I don't look at non-statutory programs?
No. I think our submissions on 19AG have to be informed by the dilemma of rehabilitating terrorist accused in the forensic setting. That's what makes the repeal of 19AG make it, I guess, that's what gives it force, that urging for repeal. There are calls in the submissions of the Law Council of Australia that the recommendations of the Harper-Ley Review be encouraged, and I take your point that perhaps that's beyond the direct scope of this hearing. However, I mean, it's evident from the kinds of questions that have been posed to government authorities in this setting that 19AG can't be considered without considering really this emerging body of evidence about the radicalisation and de-radicalisation of young people. And so that's where it does become relevant. And that's why we have, as a law firm, urged this kind of package of rehabilitation, as it were, where we can.
And where is that in your submission?
You'll find it at paragraph 41 down. And then you'll also find reference to it from paragraph 65 moving forward, which takes a more expansive approach to this question and refers to the Victorian Government's expert panel on terrorism and violent extremism.
Right.
And I say this without at all discounting the very good work that both PRISM and KISP are doing once an offender has been sentenced. But those programs are of no utility to a sentencing court, to a bail court, to a control order jurisdiction.
So what we should do is we should follow through the recommendations set out at paragraph 67 and see to what extent they might be applicable at the Commonwealth level, because the Harper-Ley Review related to Victorian law, did it not?
Yes, that's correct. The funding for these programs, as I understand, is jointly administered between federal and state budgets.
Yeah. And it's not that I'm not interested in them, but as I say, I can't make recommendations, or I don't monitor the operation of non-statutory programs per se. But I understand your submissions about 19AG, and of course you're in good company, including with the Judicial Conference of Australia, which says that that should be abolished. If you have a look at the have you got my opening there?
Yes.
If you just have a look under the heading, you do? If you just look under the heading Preliminary Insular View concerning 19AG, I might just finally ask you whether there's anything you wanted to add to those legal propositions.
Sorry, which page is this?
It's towards the back end.
Sorry, I've got it in large print. Its heading is Preliminary View on
Yes.
19AG. Just have a read of it.
Yes, that certainly captures our view of the reasons, I guess, in the narrow sense why, well, not narrow, but for the purpose of this review, certainly, the primary objections. We thought it really necessary to broaden the ambit of our submissions because the Syrian conflict has, in our view, from our firm's view, really changed the profile of offender. And it's been several years where our firm has had to shoulder this particular burden pro bono. And that's why we wanted to make that as forcefully as we could.
No, I'm very grateful. So if you want to expand on footnote 70 and send us a further note in the next couple of weeks, I'd be
Yes.
very grateful.
Yep.
But if there's nothing further, it remains for me to thank you very, very much for making your way here. We've found it of great assistance what you've put forward, and we wish you well in your future research.
Thank you.
So, ladies and gentlemen, that brings today to an end. I thank all of you who have attended for doing so, and I hope many online as well. I thank my Principal Advisor, Mr Mooney, my counsel assisting, my solicitor assisting, and particularly I thank Miss Arthurson, who has organised the day to run without flaw. So thank you and good afternoon.